I will continue in English because my slides are in English, and I was thinking of speaking Bulgarian and showing the slides in English, but I think this will confuse mostly me and then probably you. So I will continue in English for the sake of simplicity. I will speak about the European arrest warrant and its implementation from the viewpoint of the procedural rights of those requested by a European arrest warrant, not necessarily the fundamental rights as we know them from the European Convention and the Charter of the European Union, but rather the procedural rights that are provided for in some EU procedural directives and framework decisions. I know that you know this, but I want to just give a very brief insight of not exactly what the European arrest warrant is, but rather how the European Commission sees the European arrest warrant, what, according to the European Union, the basic advantages of the EAW actually are. So basically, this is a thing to replace a simplified way to replace the formerly used extradition procedures among the members of the European Union. The European Commission has, similarly to what Sergio said before me, considers the European arrest warrant as the most successful instrument. This is taken from a European Commission report, the most successful instrument of judicial cooperation in criminal matters. The thing is that it is based on the principle of mutual recognition, and that's why it operates mostly by direct contacts between judicial authorities. And of course, something that you know, it may be issued both for either for prosecuting a person or for execution of a penalty imposed on that person. What are the main advantages of the European arrest warrant according to the European Commission? Speed is number one. There are strict time limits that are, you will see later, usually observed. And these limits are 60 days for a final decision when there's no surrender consent, and 10 days when there is such consent after the person is arrested. And also as the person should be practically surrendered as soon as possible, usually no later than 10 days after the final decision. Second major advantage, through the framework decision, the principle of double criminality is actually abandoned for a certain categories of crime, 32 categories of crime, terrorism included. Another advantage, and as because Sergio mentioned several times, politicizing some of the processes, is that the European arrest warrant is considered an instrument to avoid political involvement, because it goes from one judicial authority to another judicial authority directly without going via a political institution, which would be a Ministry of Justice, for example, or a similar institution. The next advantage is that actually countries can surrender their own nationals, which was not that typical before, because countries in terms of their national sovereignty and jurisdiction and many other basic principles would prefer and insist on actually prosecuting their own nationals themselves rather than surrendering them to another country, whatever that country might be. And of course, limited grounds for refusal, but that I suppose you know. Sergio mentioned that it's the implementation of European arrest warrants is increasing. And this is basically evidenced by the data of the European Commission. Unfortunately, there is no, the way the data is collected is not very reliable because it's done through questionnaires that are sent to national ministries and national authorities, and the information is collected back. As you see, there are 3 countries that didn't provide data. Bulgaria is one of them. Regretfully, this is the case for several years back too. But you can see also that other countries have also not provided data. But the thing is that the implementation is actually growing. I would not go into details for this particular. The figures, you can find them in the reports of the European Commission. Types of offenses, of course, property crime, like theft and other similar crimes are the majority of cases. But I would like to draw your attention to the fact that in 2% of the cases, which I think compared to the number of arrest warrants actually issued across Europe is relatively high, the 2% are cases related to terrorism. As I mentioned before, the average time limits to make a decision in most countries is basically within the requirements of the European Commission. Again, the reliability of this data is quite questionable, but still it shows a certain a way to look at the big picture. And this is what I mentioned before. Like in almost 1/3 of the cases, countries are surrendering their own nationals or residents, which is a serious difference to the traditional extradition procedures before, and also poses many other questions also in terms of fundamental rights and so on. So this is the background. And these are the procedural rights that are associated with the execution of a European arrest warrant. Interpretation, information, access to lawyer, the right to have a third party informed, the right to legal aid is missing, I don't know why, and some procedural safeguards for children. Yeah. What I'm actually going to talk about in the next like 15 to 20 minutes are the conclusions of the Fundamental Rights Agency on how these rights that you just saw are implemented in practice in European arrest warrant proceedings. The report is from 2009, and it was based on fieldwork research, which means that interviews were carried out with defendants, lawyers, police officers, judges and prosecutors, and also members of detention monitoring facilities, like the national preventive mechanisms. You see that the research was done in 8 countries, and the reason why I am presenting this is that the fieldwork in Bulgaria was done by us, by the Center for the Study of Democracy. Me and some of our colleagues were actually doing the interviews. Here, a big thank you goes to the Bulgarian prison administration, which made it possible for us to go and interview actually persons sent to Bulgaria under European arrest warrants that were staying in Bulgarian prisons. We were able to meet these people and talk to them, getting their experience from the countries where they were actually arrested before being sent to Bulgaria. So as you see, it's more than 250 interviews in all these countries, almost 30 conducted in Bulgaria. And this is basically what this research found out. In each of the following slides, you will see on the right-hand side quotes from interviewees. These are direct quotes, what they shared about their experience in terms of protection of their own procedural rights during the proceedings. I will go briefly through the main issues that this research found out. I would like to make a very important disclaimer. I will focus on the problems, but otherwise there were also a lot of positive things that the research found out. That, for example, the right to information is always observed. People are always provided with information, but as you can see on the slide, these are the problems related to how they are basically provided with this information. So, although the right to information is usually observed, the deficiencies, the problems, the issues are related to the timeliness of providing this information. Usually, in many cases, this is not done immediately upon the arrest of the person, but a certain time afterwards. The language barrier, the language in which this information is provided, and the extent to which the arrested person is actually capable of understanding what they are told. Don't forget that we are talking about people usually arrested in another country, most probably not fluent speakers of the language of that country. Connected to this one is that authorities either do not have the tools or do not have the willingness to check for themselves to what extent this information, the information they are giving, is being understood by the persons receiving this information. And specifically, one serious deficiency, at least in many countries, is that the information about consenting to surrender is not always clearly given, properly explained, and as a result, sometimes it's misunderstood by the persons that are receiving this information. And the consent to surrender is an important aspect of the European arrest warrant, as you will see later. The right to have a lawyer, it's a very complicated thing in European arrest warrant proceedings, because basically you have that persons requested and arrested under European arrest warrant proceedings have the right to have a lawyer in both countries, the issuing country and the executing country. This is not always known. In the course of the interviews, I would say not in Bulgaria, because in Bulgaria, it seemed that prosecutors and judges were well aware of that fact, but in many other countries, judges and prosecutors actually considered the right to a lawyer in the other country a problem of that other country. So in addition to delays in providing this information, and there's a lack of interpretation issue, and lack of interpretation meaning that interpretation is usually provided, but it is limited to these stages of the proceedings where a public authority is involved. It's the questioning, it's the hearing, but this interpretation usually does not cover the private communication between the arrested person and the lawyer. And linked to that, in many cases, arrested persons are not at all allowed to speak to their lawyers in private, or the time they are allowed to speak to their lawyers in private is so little and so randomly chosen that is actually not effective. There's a difficulty in the communication between the two lawyers in cases where the person has lawyers in both countries. And this is due to a variety of reasons: language barriers, trust, you name it. But in many cases, the communication between these two lawyers is key for an effective protection of the rights of the arrested person. Authorities, as I mentioned, in the executing country are rarely proactive in helping the person find a lawyer. They usually tell that person that they have the right to have a lawyer in the country requesting them, and that's it. Of course, to many of them, this is more than natural because, for example, a Bulgarian police officer, for them would be a problem to know the lawyers in Austria and help arrange for a phone call or suggest, I don't know, a website with telephone numbers, etc. So this is something in which direction maybe there's a need for some improvements. And also there are payment issues, because the person arrested in one country sometimes cannot pay to the lawyer in the other country just because they are arrested. And if they don't have a proxy, a relative, a friend who can actually make the payment from a Bulgarian detention facility, I'm not sure you are able to pay to a lawyer in another European country. That would be tough to do. And in many cases, the lawyers in the issuing country, they expect a certain prepayment to be able to get involved with the case. Next thing related to lawyers again is the right to legal aid. The good thing is that legal aid is basically available across the EU for European arrest warrant cases. In Bulgaria, this is, I think, in 100% of the cases, lawyers are legal protection is mandatory, and in this case, if requested, legal aid is available. But there are also issues. But there are also problems. One problem is to properly explain to the arrested person what is legal aid and that they are authorized to use legal aid if they wish. Limited to no right in the selection process of in the process of selecting the lawyer. This is quite important because we don't speak here about naming a certain lawyer, like naming the best lawyer in the country because he or she is in the newspapers, but basically setting up some very, very, very basic criteria on what the lawyer is expected to be able to do. For example, speak a foreign language. In many cases, lawyers automatically ex officio assigned to requested and arrested persons do not speak another language, a second language. And this, related to the issues with interpretation that I already mentioned, means that quite a share of the communication between the two is actually not working. The quality of legal aid is another issue. I don't think that this is specifically related to European arrest warrant proceedings, at least in Bulgaria, and I know that in many other countries, the quality of legal aid is not that good as expected for a variety of reasons, poor payment, etc. But what the research of FRA and our own research clearly showed is that in many European arrest warrant proceedings, lawyers that are appointed free of charge by the state either lack the necessary legal knowledge, and by lacking the necessary legal knowledge, I mean legal knowledge specifically related to the European arrest warrant and the specificities of this kind of proceedings, or they lack any linguistic skills different from speaking their own language. The right to interpretation was mentioned several times. Interpretation is always provided when the arrested person does not speak the language of the country in which he or she is arrested, but it's not always provided at all stages of the proceedings. Usually, interpretation is not available during and immediately after the arrest. To the opposite, it is almost 100% available in court hearings. This being said, the quality of interpretation is a huge problem. It's a huge problem, A, because the quality is poor, and B, because there's no way for authorities to basically understand that the quality is poor. In most of the countries, the research showed that nobody is actually taking care of what the quality of interpretation is. There's a minimum of criteria, and this is the interpreter knowing the language and basically speaking something during the procedural action, and that's it. Nobody actually is not only doing, but nobody is actually able to understand whether this interpretation is accurate, and if everything that is said is being translated, etc. I will close basically my presentation with a case from Bulgaria, because as you probably have seen in the agenda, I was thinking of speaking mostly on the procedural rights in European arrest warrants warrant on terrorism-related cases. But while I was preparing for this presentation, I found out that the issues and the problems are pretty much the same, no matter for what crimes persons are requested and arrested. But nevertheless, this is a case from Bulgaria. For our Bulgarian colleagues, probably it's gonna be a well-known case, but for our colleagues from other countries, it would be interesting to go into a bit more detail for a couple of minutes. So this is one of the very few, if not the only, case where a European arrest warrant was executed in Bulgaria in relation to pending prosecution for terrorism. It was received from Germany, from the General Prosecutor's Office in Munich, as you see, in 2018, for basically two crimes. One is the preparation of serious acts of violence endangering the state, manifested by undergoing training for terrorist purposes, and intentional possession of weapons, unauthorized intentional possession of weapons. The facts, according to the European arrest warrant, so the requesting person was born in Moscow, clean criminal record, university education, German nationality, divorced, no address in Germany. In 2014, he left Germany for Russia on a tourist visa. While in Russia, he underwent paramilitary training, and from September 2014 to February 2015 was involved in military actions in Ukraine, using obviously a military assault rifle Kalashnikov as a weapon. For this reason, these two accusations arriving from the prosecutor's office in Germany. According to the prosecutors, everything with the European arrest warrant was okay. The information was completed. Double criminality for the terrorist offense was not required. For the possession, for the unauthorized possession of the weapon, it was required, but it was also present because it is a crime under Bulgarian Criminal Code. The German authorities have the jurisdiction because the person at that time was a German national. In addition, explicit guarantees were received that no prosecution on the grounds of ethnicity and political opinion would take place. And there are no formal grounds for refusal, neither mandatory nor optional. The lawyers, however, tried to oppose the execution of the European arrest warrant, mostly by trying to explain that some of the actions were not basically a crime, but also expressing concerns that the prosecution in Germany would be on the grounds of political opinion, because the arrest order issued in Germany, on the basis of which the European arrest warrant was issued, said that, as you can see it in the last bullet, according to the detention order, the person considers the armed struggle against the Ukrainian state regime as a legitimate means of enforcing pro-Russian interests and denies the values of the democratic order. The defense, basing their arguments on this particular part of the detention order, claimed that the person would be actually prosecuted for his political convictions and opinions rather than the crimes mentioned in the European arrest warrant. The request for execution was found justified, and actually the European arrest warrant was executed. These are the main arguments of the court. I would not go through all of them, but I would underline two very important things. That one is that the Bulgarian court is not supposed to question the validity of the decision of the German court, which is the second bullet on the slide, which is important for European arrest warrant proceedings and is very often a matter of interpretation in court decisions. And the other thing is the last but one bullet on this slide, that there is no evidence of deficiencies in the conditions of detention in Germany, which would expose the person to inhuman and degrading treatment within the meaning of Article 4 of the EU Charter of Fundamental Rights. As most of you probably know, and this is also a link to what Sergio said about conditions in Italian prisons, but similarly in Bulgarian prisons. Poor conditions of detention facilities are grounds for refusing to allow the execution of a European arrest warrant if the conditions in the detention facility in the issuing state are so poor that they would expose the person to inhuman and degrading treatment. I think that in the case of Bulgaria, we had a couple of European arrest warrants refused by German courts, specifically on the grounds of detention conditions in Bulgaria. And to conclude, which to me was in fact a bit curious. Honestly, I don't know how often this happens in European arrest warrant proceedings, but basically 1 year after the European arrest warrant was executed, the Bulgarian court received a new request because the investigation that was undergoing against that person after he was sent back to Germany expanded the scope of crimes he was accused of. New crimes were added, again related to his time, to the times he spent in Ukraine. But the framework decision on the European arrest warrant, as well as the Bulgarian legislation that is transposing it, prohibits the prosecution of the person for other crimes committed before he was surrendered and not included in the European arrest warrant. So for this particular case, a second proceedings took place 1 year later, when the Bulgarian court was again approached with a request to give an additional consent for the person at that time spending some time in a detention facility in Germany to be actually prosecuted for more crimes than the crimes included in the original European arrest warrant that were all committed before this person was surrendered. And this decision, this consent was actually granted. But again, to me, I was curious to see that these follow-up proceedings are also happening and that courts, because there's a principle of speciality. And actually the person, this German guy before the German court said that he explicitly renounces the application of this principle. So in order for this person to be prosecuted for more crimes, Bulgarian courts were supposed to be approached and provide explicit consent for this to happen. This is where you can find more information. Thank you for your patience. I know that for some of you these were not new things, but I hope at least part of it was new. And I'm also open for questions. We have like 10 to 15 minutes for discussions before we go to lunch break.